Good afternoon, everyone. Please meet Paola Minekov. She's a London-based visual artist whose work blends bold color, movement, and narrative to explore themselves of identify memory and transformation. With a background in fine art and animation, her career spans international exhibitions, public commission, and collaboration with institutions such as the European Parliament. As a co-founder of Creation Atelier, Paola champions emerging creatives and promotes the intersection of artist freedom, professional sustainability, and legal literacy. Her practice extends beyond the canvas into the education, community engagement, and empowerment of fellow artists. Passionate about the rights of creative in a digital world, Paola brings a unique combination of artistic insight and practical knowledge to every talk, making complex topics like copyright accessible, engaging, and relevant. Please, Paola, thank you so much.
Hello, everyone. Today we're going to talk about copyright. Uh, a small legal disclaimer in the beginning. I am not a copyright lawyer and this is not legal advice. This is just an overview of copyright basics for people who want to use images and artists who are wondering how they can protect their own work. So, what we're going to cover in this presentation is what is copyright. Is an artwork copyrighted? How to use copyrighted artwork? We're going to talk about copyright infringement and how to find and use royalty-free content. So, what is copyright? Copyright is the right to prevent others from copying your original creative artwork. And by artwork, I mean any imagery, music, text, anything like that. Now you cannot copyright an idea. If I said that I wanted to paint the sky blue, then I can't copyright that. What I can copyright is a painting that of the sky that is blue that I have painted. Now I have a tangible object, tangible creations. I can copyright that. I can't copyright an idea. Is an artwork copyrighted? All contemporary artwork is copyrighted, with the author automatically acquiring ownership of the copyright at the point of creation. So then, authors, the creators, they can license their creative work in a variety of ways, which we're going to cover now. Do I automatically have copyright? Yes. In most cases, you automatically have copyright of anything you have made. In some countries, like America, you can go and register your copyright. In most other countries, the moment you make something, it is yours. And ideally, you'd be able to prove that. So, the moment you publish it on your website, in books, magazines, if you have photographic material, evidence showing you creating your artwork, then you can prove that it's yours. Uh, if you co-create an artwork, for example, a painting together with somebody, if I made a painting together with Natalia or with Rosella, then we would both have the copyright to that painting. Similarly, if you are a music band and you write and perform a song together, then you would all have the copyright of that song. There is a small caveat when you create artwork or content while you're at work. If you're employed by a company, then they will own the copyright of anything you create during your working hours and on their devices. So, for example, if I have my web design agency, if I have a designer working for me who's employed by me, then the designs that they create will belong to my agency. I will not be saying that Paola Minekov made them, but they will belong to the agency. And that is on perhaps a smaller scale, but it applies to large companies as well. For example, if you work at a large company like Google, anything you make during your working hours on your Google computer will belong to Google and not to you. And that is important to mention for some of the things we'll cover Next, how long does copyright last? It doesn't last forever. Nothing lasts forever. So, copyright of written dramatic, musical, and artistic works, and that includes sound, music recording, films, lasts for 70 years after the author's death. It may change and it might be different in some different countries. So, you're always encouraged to check what the copyright law is in the country where you are or where you want to use a particular piece of content. But going back to what I mentioned earlier about copyright belonging to a company when it's created within a company is an entity, it's a legal entity. So William Morris is a good example for that. Now, Morris passed away in 1896, so more than 70 years ago. So all the artwork that he created as William Morris, the artist, is now in the public domain. And you can find it on some websites. You can download it, you can use it, you can print it on your own products, you can print it and put it on your artwork, and so on. It's free to use. All the artwork that William Morris created as part of his company Morris& Co., and all the designers who worked in that company, that belongs to Morris& Co. Morris& Co. as a brand still exists today. It belongs to another company, Saunders and Sons and Liberties, I believe. And all those designs you still need to get a license for if you wanted to use them. You can't just go and use them. An interesting new development, and it's relatively new, right? Because AI has only been around for a few years, is AI and copyright. Now, if you use AI to generate a piece of art, writing, music, or other content, video now is like you can generate insane videos with AI. Who owns it afterwards? And that is still a bit tricky and unclear. But with most established AI models, you can use the artwork commercially. A nice example I wanted to mention is that of our member Christina Castanova, who took part in the Creations Atelier exhibition Metamorphosis. Now, Christina, she got into AI very early on, and she created the first AI generated comic book. And then she went and copyrighted that. She now lives in America, so she actually registered the copyright. So she got her documents, and then the copyright was taken away from her because they claimed that this was not her work. It was generated by a machine. And that became a very complex legal case with different organizations involved, including, I believe, Midjourney, where she generated the comic book. You can look up the complete story on the internet if you just Google Chris Castanova and comic book. But what eventually happened is that she was given the copyright of the text and content back, but not of the visual imagery, which they claimed was not hers. So I vaguely covered that, but yes, it does matter in which country I'm in terms of copyright. Different countries have different copyright laws, but there are still international agreements that would protect your work regardless of where you live and where you registered the artwork if you did register it. Let's talk a little bit about how we can use copyrighted artwork and the types of licenses. Common way of using copyrighted artwork, so contemporary work, writing, videos, imagery created by contemporary authors, would be fair use. And whether we can use that in fair use or not depends on the amount, purpose, and the effect it has on the original author. So if we only use a little bit of the original writing, video material, or imagery, then we could potentially claim fair use because we're using a little bit to make some kind of a point. For example, if I'm making a political point in my art and I took cuttings of a newspaper and used them as collage and change them completely, then that could be fair use. We have one of our members, Michelle Baharier, did that with one of her portraits of a disabled journalist, and that is quite often that people would use press cuttings, newspaper cuttings, and magazine cuttings in their collages, but they use them differently from the way they were originally used. They changed the use case, and therefore it's fair use. So Michelle painted the portrait and used paper clippings in the background, and that is fair use because she was making a point that the model, her sitter, is a journalist and he has brought an important story to life. If you just take a page of a magazine and, I don't know, stick it on a canvas and say, "This is my art," then that is not fair use. That is copyright infringement of that magazine. The purpose of fair use, so for example, commercial use is less likely to qualify for fair use. If I'm using somebody's work to sell, then it's less likely to be fair use, and I'm not changing obviously the meaning of it like Michelle did in the earlier example. And then we need to talk about the effect, like does it have a new effect on the original author somehow? And this is not to say that you have to only say positive things about other people, but creating something more derogatory, using it in a way that may insult the original artist somehow, is more likely to get you in trouble than using it in a positive way. Fair use is often used in research, scholarship, teaching, education, news reporting, and criticism and comment. So, if I'm creating a piece of art, again, that's some kind of critical piece on, I don't know, the state of the world, then using paper clippings might be very appropriate. Or if it's multimedia work and I'm using like a, I don't know, a famous actor saying something, and I'm just using this one bit as part of my artwork, I don't know, 3 seconds of a video or whatever, then I can probably claim fair use. If I put 10 minutes of a film in an 11-minute video multimedia artwork, then less likely to be fair use. So going back to that example about videos, how YouTubers do it, well, that is how they do it. So the amount of the original video content of interviews or part of the film that goes in their video would be relatively small compared to them talking, for example, and providing a level of criticism, positive or negative, about that video material. For instance, zooming in and out, putting text over it, various effects, and providing commentary, changing the meaning, or educating is all fair use. We're going to cover copyright licenses. So, if you want to use someone's music, film, video, or other creative work, you can just contact them first and ask for permission. A lot of creatives will probably be flattered and quite happy to collaborate with you. Some creators have agencies in the UK that would probably be Dax is a popular one, uh, who handle the copyright licenses for them. So most common license scenarios would be limited use license, an exclusive license, and the Creative Commons license. Limited use may refer to, I don't know, how we limit the use of a particular piece. So, for example, a font may have a number of different licenses to use online for print and so on. The web version of that font, then all we can do with it is use it on our website. An exclusive license, a good example of an exclusive license would be, for instance, if we create as a design agency, if we create a logo for a client, we would probably be granting them, in all likelihood, an exclusive license because it wouldn't make sense to sell the same logo to somebody else. Similarly, if somebody takes photos of you, the copyright holder would be the photographer, unless you have an agreement for them to grant you the copyright. So the photographer will remain the copyright owner, but they will probably grant you an exclusive license to use your photos, because again, it wouldn't be very ethical for them to sell your photos to someone else. um, when I create digital portraits of my collectors as an artist, I also grant them an exclusive license, because I mean, there's not a chance that I'm going to sell a picture of somebody's grandchild or child to another person, right? So they get an exclusive license from me, and I'm quite flexible about it. So I just allow them to use their images in whichever way they like. A Creative Commons license is basically a license to use the artwork for free in most cases anyway. So if I wanted to give a license to everybody to use my art, I'd probably license it under the Creative Commons. Now, you as artists probably don't want to do this because you want to retain ownership of your work. But a lot of people do license various things under the Creative Commons license. I did not put that in the presentation, but I'll just briefly mention editorial license. Editorial license typically is for images of famous people, which you can only use on say blogs, websites, print publications. So, for example, photographers grant editorial license of pictures they've taken at red carpet events, and you can only use these to cover the event. For example, you can't use them to put on a t-shirt and sell a picture with, I don't know, Britney Spears to everybody, because that would be commercial. Copyright infringement is a really important one because it does happen a lot. A famous case is that of Queen and David Bowie, who some years ago sued Ice for the song Ice Ice Baby, which turned out to be too similar to the song Under Pressure. Now, they won that case and received songwriting credit. It has happened to many of us to see our pictures republished on the internet without a license. What we want to do with that and whether we want to take it further is our choice. But basically, unless you've granted the license, people can't do that legally. They can't print them, they can't put them on products, they can't sell giclée prints or greeting cards of them, none of that stuff. So if you're a blogger and you've used a commercial picture without an editorial license on your blog, the photographer can ask you to take that picture down, or the publication for that matter. And that's based on a real case that happened. The blogger on this occasion claimed fair use for using the photo on the blog, and that went to court, and the court ruled that the blogger needs to take the picture down. Another real case we found for this presentation would be that of a tattoo artist. You can't, if you're a tattoo artist, you take somebody's image and you tattoo it on a client, then this is commercial. You probably get paid or whatever the situation is. Even if you don't get paid, you can't take my picture and tattoo it on somebody else. That is not fair use. Uh, and again, going back to editorial, I thought I'd mention here the copyright of your publications, because we've done some PR work before within Creations Atelier. If you have been published in a mainstream publication in the UK, probably in most of the world really, but in the UK specifically, there are organizations that handle the licenses for most mainstream publications, that is newspapers and magazines. The moment your words are printed in a mainstream publication, then that publication now owns the copyright. to your words. So you can't go and use the same quote on your website and say, I was published in Marie Claire and I said, quote. That would be illegal and can get you in trouble. The fines can be quite hefty. Similarly, you can't take a screenshot or a photo of the magazine and put it on your website. In reality, you also can't email it or put it on social media with commercial purposes without a license. Those licenses start at, I don't know, maybe £150, but there's different licenses. Similarly to the fonts, you have a license to email, you have a license to feature a particular publication on your website, and so on. I believe the organization to go to and check for those licenses would be the NLA. And yeah, the fines can be in the thousands. Obviously, for a small business, probably not in the many thousands, but it could be a few thousand. So don't do that. There is ways to do it, and we have created for Elysium our online magazine. We have templates which would help you share your media coverage in a safe way. So that would typically be, you can share the log of the publication, that's okay. You can share you've been in it, you've shared what you've talked about, not as a quote, but you can say, I talked about XYZ in a publication in, I don't know, Stylist. And you can put a picture, which is not a picture, a snapshot of a screenshot of the magazine or a picture of the publication, but it can be a picture of you. And on top of that picture, you can even put a logo, things like that. So we'll put a link to where you can download our templates. We have templates for social media posts, which can also be used for your website, and for stories and reels, so different dimension. And they are, well, they're branded for Elysium, but they're also fairly neutrally branded, so you can easily apply your own branding to those if you have anything like that. So let's cover how to find and use royalty-free content. So royalty-free content, we would probably, as artists and creatives, start with the public domain. So all the old artwork, whether it's written or painted or music, is free to use as your wish. It enters the public domain 70 years after the artist has died. So you can find a lovely picture of Monet's lilies and do it as you please. It became quite popular, I don't know, maybe about 10 years ago, for museums to publish really good quality images of the artworks in their collections that are in the public domain. So a lot of big museums, you can go to their websites and just publish really good quality resolution images, which as artists, I don't know, you might want to make a really beautiful copy of Rembrandt, or you might want to put it on your blog or whatever. You're free to do that. Because there are some cases like the William Morris one I mentioned earlier, it's still always a good idea to check. But I mean, I think anything like Rembrandt from the 1600s, 1500s, whatever, that period, Impressionists, those would be free to use. And that applies, like I said, also to written content. So you like the adventures of Tom Sawyer, you can get the text and you can put a different picture in it, you can publish it on Amazon and sell it. If you want to find royalty-free images on some of these websites, you will probably also find some public domain images, but Unsplash and Pexels especially, and Pixabay are very popular for finding free images, which you can use commercially. You can use them on your websites, you can use them as stock photos, you can use them as reference photos for paintings, whatever you like. Some of those also have videos you can use. If you want other professional images for commercial use, and they come with a variety of licenses, popular websites are iStock Photo, Getty Images. Vecteezy is one I use a lot because their licensing is very flexible and they have vectors and photos and videos. Shutterstock Creative Fabrica is popular for illustrations and fonts, and of course we've got the AI image generators like Adobe Firefly or Midjourney, where with a paid subscription you can use their models commercially. Now, all of these you can buy different licenses to use for different use cases, whether it is going to be online, on products, on printed products, in digital products. So you have to check the particular license you're buying and whether it suits your needs. Similarly, you can find royalty-free music. YouTube Audio Library is a popular one. There's the Free Music Archive, Free Sound, and then you can also find audio files on iStock Photo, for example. Um, Again, there's a variety of licenses, how many times you can play a particular sound, and so on. I guess here is a good moment to mention that on social media, for example, on Instagram, you can use popular commercial music with your reels, especially if you have a personal or a creator account, and in some cases, also if you have a business account. So if you create your post directly in your Meta application, then you can use it. You cannot download it because that license is only valid for, say, Instagram and Facebook. You can't download it with the music and then re-upload to YouTube or TikTok, who may not have a license for that particular piece of music or audio. So it used to be possible to download your reel with the music on. I think now you only, if you want to download your reel, you do not get the audio with it anymore. Of course, you can hack that, but if you didn't, then you uploaded it elsewhere, you would be infringing on the musician's copyright. I think this concludes our copyright basics presentation. I hope you found it helpful. Thank you.
Thank you so much, Paola. I want to do a call for action to all the designers and artists and creatives. Join our creative community at Creation Atelier. We believe that empowering artists, designers, and creatives to thrive not just in their craft, but also in their career. By joining our community, you'll gain access to inspiring talks, practical resources, creative support, and growing networking of like-minded individuals who believe in the power of art and knowledge. Whether you're just starting out or refining your practice, there is a place for you to here. Become a part of the movement, sign up, stay connected, and let's create something extraordinary together at creationatelier.com. Also, we wanted to say that we have in place monthly networking that is going to start in September. We are looking, we're going to do an exhibition in October and stay on possibly November and December. And the topic is going to be landscape and cityscape. We're going to do lunch the 18th of July in my place for all the creatives.
Summer party, yay!
A summer party. And in August, we're going to take a break. But in the meantime, on the background, we're going to still work. And Paola is going to do the next workshop in September regarding the SEO, which everybody would love to join. And then I missed something. Did I miss anything?
I don't think you did.
Okay, cool. Thank you so much. Have a beautiful weekend all. And yeah, happy Friday. Bye.